All right, welcome to Chapter 7. We're continuing our examination of the police in this course, which is CJC 111, Introduction to Criminal Justice. This is our our introductory course that covers many of the elements in our whole criminal justice program here at Wake Tech. The text we're using again is Criminal Justice in Action, published by Cengage. It's the 11th edition, and the authors are Gaines and Miller. So we are going to start looking today at the police as they're doing their job within the background, if you will, of the Constitution of the United States. Just over here. And like I usually do, I start this chapter asking some questions maybe that you can keep in the back of your mind as you're going through this class. Which group establish or support different models of crime control and why? So if you say there are competing models for something, competing reasons why something's happening, one of the questions is which stakeholder, which group is pushing which model, and what are they getting out of it, or how are they benefiting from it? So as we start to talk about crime control versus due process, you might say, well, attorneys just want due process because that means more trials and that means more money for them. And people might counter by saying, well, then cops want crime control because that means more cops and more money for them, if you were just looking at it in an economic sense. But I think there's, social, political, and I don't think single reasons for doing things is a very smart way to look at that stuff. Does generational ignorance about technology lead to fundamental problems and misunderstanding? So we're going to talk today about some of the problems with my generation, because I'm a child of Eisenhower. I was born during the Eisenhower administration at the end, but do people like me who don't understand much of modern technology, does that lead to problems, particularly when you say, well, the bench, the people making a lot of the interpretations and rules, are seniors, people over, say, 55 or 60? Why is stop and frisk limited to street crime and weapons and not white-collar crime or corporate offenses? If you say that you can suspend the Constitution for the safety of the officer, couldn't you suspend the Constitution, at least temporarily, for the safety of the greater society? So why do we limit those things? All right. The learning objectives here, again, you've seen these over and over and over again. These are just quick major topics that we're trying to cover. Okay. So this quote is from Benjamin Franklin. There's a picture of old Ben there, reading, I guess. Looking a lot better than we kind of picture him. I think we always picture Ben Franklin bald, holding a kite in his hand, if you will. Now this quote is taken a little bit out of context, but it says, "Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety." Sometimes quotes can, I don't think that they're necessarily wisdom imparted automatically. I think a quote can often open your mind to think about things. So I think you've got here, at least from one perspective, a struggle between the idea of we want to be free and we want to be safe. If you give up too much safety in order to be free, it's not a very nice society. Complete anarchism can be, at least, a very dangerous place. Conversely, if you give up all your liberty just because you're safe, again, that's not a very nice place either. A police state, a fascist state, is not a locale I think most people would want to live in. Okay, so I talked about these two broad theories of law enforcement before: the crime control theory and the due process theory. And there is a tension in our society, and I think a tension inside individuals, between being free and being safe. Under due process, there are rules that you have to follow, and that preserves liberty. But that comes in conflict with the police, who are doing the job and following the rules. Now, I think it's fair to say that the extremes, ironically, fail in both ways. So if you create a society which is rigidly due process, that has nothing to do with due process, it isn't any freer than one that has no due process rules. Because if there is no crime control, you're not free. Extremes rarely lead to the goal that they seek. Okay, this is the Fourth Amendment. Now, this was drafted around 1780 and has been subject to 240 years, I guess now, 200 plus years of interpretation. So quickly, what's the Fourth Amendment? It says, the right of the people to be secured in their persons, comma, houses, comma, papers, comma, and effects, comma, against unreasonable searches and seizures, comma, shall not be violated, comma, and no warrant shall be issued, comma, but upon probable cause, comma, supported by oath or affirmation, comma, and particularly describing the places to be searched, comma, and the persons or things to be seized. Very long sentence, almost a run-on sentence, although not really, and a lot of commas in it. It's a very brief, I mean, it's 20, 30 words, it's very brief, but it really has been subject to so much litigation as to what it means. Now, you notice there's no asterisks in there to explain what words mean. There's no parenthetical statement of, except in this case, or when this happens. It's really a broad statement, and part of the Constitution's, I would say, genius is the idea that the Founding Fathers knew that they could write a guiding document, but there was no way they could make it so specific to include every possible combination of events. So instead, they established general principles and then gave the authority of the courts and the people to interpret those principles as they saw fit. So that's what the Fourth Amendment is. It's interpretation for 240 odd years, and creating the society we live in today. So the Fourth Amendment has two critical legal concepts in it. First, there is a prohibition against unreasonable searches and seizures, and second, the requirement that probable cause has to exist in order to get a warrant. Now, that's a warrant both for arrest and for search. So this raises the first one, with the prohibition against unreasonable searches and seizures, raises the question, what is a search? If I just look at someone and I'm searching to see if that's the person I want, that's not really a search in a classic sense. If I don't lay hands upon you, if I don't commit a trespass, is that a search? If I look through your garbage, is that a search? What is unreasonable? Remember, it's unreasonable searches and seizures. When does it become unreasonable? Again, this is left open to that interpretive dialogue that the generations have. And what's a seizure? And a seizure, shorthand, can be an arrest, but when is someone in arrest or a stage before arrest, like custody for questioning? Does that count? Now, the second big part of the Fourth Amendment is the requirement of probable cause to issue a warrant. Notice it doesn't say probable cause is this. So what is it, and when does it exist? And again, I hate to sound like a broken record here, this is just something that is left up to the interpretation of the judges who are looking at the Fourth Amendment now and saying, this is what probable cause means. In this instance, this exists or it does not exist. All right, so reasonableness, as we look at this, first of all, the term reasonableness is something that is going to vary in each case. And the police must be reasonable when conducting a search or seizure, both in their specific behavior and in creating the rationale for the search. There is no specific meaning that applies to every case that ever happened. And reasonableness is linked to probable cause. So you could kind of think of it this way. The stronger a body of evidence and logic you have that would establish that you should be able to search or you should be able to arrest, which is what seizure is, the stronger your probable cause. The more evidence you have, the stronger. And of course, the more serious the crime, usually, the stronger the evidence you need. If you think someone jaywalked, you could just see them suddenly moving in a different direction when you thought you saw them before, that would be enough to at least stop and talk to them. So here are some ways in which probable cause comes into existence. First, personal training, observation, and expertise of the police officer. And we're talking about how the police create it. So if a police officer looks at someone or sees something happening or is an expert, let's suppose now North Carolina has a statute that about being intoxicated in public. You can be intoxicated in public in North Carolina, but you can't do certain things where you're drunk. Then it becomes what we call in North Carolina drunk and disruptive. And those things are blocking an entrance or an exit, causing a fight. There's a few others. But basically, let's suppose someone is being belligerent and a cop says, I wonder if he's intoxicated. So he's going to have some training to recognize if people are intoxicated. And he'll have his own expertise as a police officer. And that intoxication might be something like alcohol, or it could be something like drugs. I mean, you might go up to someone, you don't smell the sense of alcohol, or the odor of alcohol, the scent of alcohol on them, but you might have, arrested 50 people for cocaine or heroin or meth, and say, oh, I know what that is. That's that drug. Information. You might receive information from others, and of course, it's got to be reliable. If one of these, cocaine addicts comes up to you and says, "Hey, 3 men from Mars just landed and told me that Fred over there is the one that was robbing the liquor store." Well, that's not a very credible source. That wouldn't be a very strong probable cause. Certainly not probable cause enough to arrest somebody. On the other hand, if a fellow officer came up and said, "Hey, I need your help. I just saw Fred over there rob the liquor store." That's a believable source, credible source, reasonable for you to act at that point. You have the existence of probable cause. Now, of course, what his lawyers will do, Fred's lawyers, is they'll back up. They'll say, okay, you might have had the authority to do it, but let's talk to the guy that gave the information. Evidence. Now, you can have physical evidence, for example, stuff that exists in plain view, something we'll talk about. But, if you suspect someone is smoking a joint and you look at his hand and there's a joint, that's pretty good evidence that he's smoking a joint. The weakest type, and people still use this, but it's the weakest type, and usually the courts are the most suspicious of this, is association. If you are in a location where crime frequently occurs, or if you are with people who aren't good people, put it that way, then does that give me probable cause to arrest you or search you? And the answer there is probably no, most of the time. You can be places there are people that are trying to get prostitutes off the streets and provide them alternatives, or help drug addicts recover, or help the poor and the homeless. And they can be in terrible areas, and they can be associating with terrible people, but they have a noble cause. So simply being in a place is not probable cause to say, hey, I'm going to arrest you because you were with that prostitute, or hey, I'm going to arrest you because you were with that drug addict. Generally, mere association is not a strong enough reason. All right, so let's apply this Fourth Amendment, and let's see how it limits search and seizure. So the Fourth Amendment exists, and it really says if you're going to do any searches or seizures, you got to use the Fourth. And what happens when you don't? Well, what happens is something called the Exclusionary Rule. The Exclusionary Rule was developed in the early part of the 20th century. There was a series of cases. Again, if you take our constitutional law class, we'll walk through how first it was in the federal courts, then it was in federal courts but applied to agents of the federal government who were operating in states courts, then it applied to everybody. The Exclusionary Rule says if you have an illegal search, so I have a search that didn't have probable cause, that was not reasonable, and I find evidence in this unreasonable search, I can't use it against the defendant. Now, it's actually a little bit more specific than that. You can't use it against the parties whose constitutional rights were violated. So, quick example here. The police are raiding John Doe's house. They don't have a warrant. They enter John Doe's house. They search it. They find a gun that was used to kill Fred. John Doe gets arrested. He utilizes the exclusionary rule. His lawyers argued that the evidence should be excluded. Now they're probably going to win, a home search without a warrant. But let's suppose that that gun, okay, wasn't just John Doe's, but let's suppose there were two people in the homicide, John and Peter. You can admit the gun against Peter because Peter's constitutional rights weren't violated. Only the person whose constitutional rights were violated has what we call in the court standing to object. Well, why do you have a rule like this? Why are we letting John off when it's his gun? Well, the answer is it forces the police to gather evidence correctly. If you told the police you have to get a warrant to conduct a search, and the natural response is going to be, what if I don't? If you say, well, nothing, we're still going to use the evidence, they're going to say, gotcha, we're not going to go bother you to warrant. Because people are going to do whatever makes their life better, faster, more convenient. Why would they bother to go get warrants? Also, I think you have to understand there's very few violations of the exclusionary rule that get up to the court system. It's pretty rare. We also have a extension of this. Your book mentions it's a little bit more complex, but basically it's called the fruit of the poisonous tree, which says if we have an illegal search and it leads to evidence, which usually by itself is not arrest of somebody, but then that evidence leads to more evidence and that evidence lets to arrest somebody, that's not admissible either. So a quick example. We search John Doe's house, we find a receipt for a gun. We go to a bank, we open the bank, the vault in the bank, there's the gun was used in the murder. The gun is the fruit of the poisonous tree. We found it because of the illegal search, it's inadmissible. There are exceptions. First of all, if we are conducting a search, we don't have a warrant, okay, but we would have inevitably have found it. Then it becomes admissible. It's called the inevitable discovery rule. So we have an illegal search or an illegal interrogation, and we discover evidence of crime. But we were already searching something where we could legally do it, or it would have been found otherwise. There was other evidence. It's pretty rare. Good faith is a big one, and there was actually a case in Raleigh that happened, and here's the facts of this case. So they basically, do the police believe that they either didn't need a warrant, or they were enforcing the law correctly, or the warrant was valid, and there was just a technical problem with it? So here's the case in Raleigh. An officer stops a car he sees going up on the ramp onto 540 or 440, I believe. And he notices that one of the two brake lights is out. Now, the officer thinks he knows at least, that the motor vehicle statutes in North Carolina require both brake lights to be working, so he pulls it over. He finds evidence of crime or criminality. I forget whether it was drugs or guns. I think it was drugs. Now, here's the interesting thing. The officer was wrong about the law. The law actually says both brake lights have to be out for it to be a violation of motor vehicle law. So he didn't have probable cause for a stop. He was wrong, but he was just technically wrong. So it goes up to the Supreme Court, and the Supreme Court says, yeah, the officer made a reasonable mistake, it's admissible. And I think this actually is part of a pattern, both the inevitable discovery and these good faith exceptions, is that the current Supreme Court is very much a crime control court in some regards, street crime at least. And they're carving out more and more exceptions to the exclusionary rule. The exclusionary rule comes in at the very beginning of the 20th century and starts to be applied in the 20s, 30s, 40s. I think kind of reaches its peak in the 60s, and then ever since then, as the Supreme Court has moved to be steadily more conservative, pro-crime control, as opposed to due process, they've limited these applications. All right, one of the things that is crucial, that at least the court have says, even though it's not technically in the amendment itself, is what is your expectation of privacy? This is a term that's used. Now you notice there's no expectation of privacy phrase in the Fourth Amendment, but it is critical to understand that the Supreme Court looks at it and says, do you as a citizen have a reasonable expectation of privacy? Now, reasonable exists, but the expectation of privacy does not in the Fourth Amendment. So the Supreme Court created a two-part test for these searches. Should a person have expected his actions to be private, and does society recognize it? So let me give you an example where we all expect our actions to be private. You're in your house, your doors are shut, you're going to the bathroom, or you're taking a shower and you walk between places of your house and you're naked. Okay? Well, you have an expectation, let's just assume you live alone, your windows are shut, you have an expectation that you can do in your house what you want. You're not exposing yourself to anybody else. On the other hand, let's suppose that you just feel that everybody should be naked and you go for a walk in the park buck naked. You might believe that your actions are okay, private, but society says, no, we really don't want naked people walking around. By and large, most people are not that attractive to look at naked. So let's kind of limit this, shall we? Another example. If you see how people behave in their cars, you will recognize that you have less of an expectation of privacy in your car than you do in your home. You'll do more things in your home than you will in your car. Now, you still see people doing stuff in car that is somewhat questionable. Putting on their makeup, singing off key, picking their nose, doing stuff that is probably inappropriate. But what we're going to say is your expectation of privacy in your car is lower. That's going to allow the police, by the way, to stop cars far more easily than they can enter homes. This gives rise to issues about technology. Now, that amendment is written in the 1780s. We have the Constitution that's being written, then we have the Bill of Rights that comes afterwards. So it's really a process from 1781 through 1787, 1789, ratification and stuff. But here's the thing. A lot of those terms, when they said persons, papers, they were talking about physical paper, things you would record like your diaries or your notes or your records, right? Or even your receipts and your bills. Well, if you think about that today, there's no physical paper anymore. For a lot of people. Most of my receipts are electronic receipts. Most of my letters are electronic letters, either an email or a text or a tweet or whatever we're talking about. So you can see how new technology gives rise to new and conflicting expectations of privacy. So let's take an email, a text, and a physical letter. If I sat at my desk and I wrote out a physical letter and I put it in an envelope and I put a stamp on it and I sealed it and I put it in the mailbox, that's what existed in the 1780s. If the police want to intercept that letter, open that letter up, read the contents, they are definitely going to have to go get a warrant. And you can't say, well, he wrote the letter at his job, therefore, he has no expectation of privacy. Or he wrote the letter using stationery that he got from school or from his work, therefore there's no expectation. The courts wouldn't buy that at all. But today, if you look at things like email, if you wrote an email at work, or if you sent an email, the courts may very well say, well, you don't have the same expectation of privacy in an email as you do in your physical letter, even though they're functioning effectively the same way. Traditionally, the courts will look for a physical intrusion or action in order to call it a search, but new technology really raises the level of what is and isn't a search. And it can be things like, it's not a search if a police officer looks at your house to see if there's marijuana growing, looks at the windows from the street. But what about if he's not trespassing again, but he uses an infrared camera? Is that a search? What about if he tries to overhear what you're saying with his ear? He's standing on the street, he's listening to see if they're shouting, doesn't hear anything. That's not a search, right? If you're screaming, you don't have an expectation of privacy. Well, what if he uses a parabolic mic? What if he uses a way to, without physically entering and eavesdropping, to listen in your conversations? This is how technology can change the discussion. Okay, so we've talked about search and seizure. A search is a search warrant. A seizure is an arrest warrant, and both types must be supported by probable cause. So what do the police have to show? Well, first of all, they have to show two factors. One, you got to show there's a crime. I can't investigate you for bad taste. If you like, I'm trying to think of something I don't like. If you like mustard on your hot dogs, which I don't, that's not a crime. Okay, we're not going to arrest you for that. The police couldn't go get a warrant to search your fridge for mustard or ketchup, right? You got to show a crime is committed. Did someone commit a murder? Did someone commit a rape? Then you've got to show that evidence of that crime, or if you're arresting the suspect, the seizure, that the suspect themselves will be in the area searched or is the person you should seize. So you got to show these two things. If you don't show the crime occurred, you don't get the warrant. If you don't show that you're likely to find evidence of the crime or to arrest the individual if it's an arrest warrant, you're not getting the warrant. That right there is a North Carolina search warrant, and you can see where you can fill in the blanks there. It says on it, North Carolina search warrant. So what you would do is, say here in Wake County, you would go up there, and I don't know if you can actually see the little arrow here, but up here where it says county, you would put Wake County, and then it would be in the matter of. That's your criminal case. You're going to say, this is regarding this case, and there's going to be a, John Doe. Here's the date that's issued. Here's who applied for it. It's going to be the police officer usually. Here is name of any additional affidavits or anything that we're attaching to it, and I certify that it's been received. And then the side to the left, these are the searches. And then if you do find anything, you check the box and say, here's what I found. That's that first box down there. If you didn't find anything, you check I don't. Or if you didn't get around to executing the warrant for whatever reason, you check it off. Now, you'll notice that over on the right side here, again, I'm not sure if you'll see the arrow there, here's where you give your justification. Now, you may attach a piece of paper to this. It may be much more, but it is it really is going to be the statement of your probable cause. And then you'll notice that you can have your typed name of the person applying for it, and then the signature, and then who issued it. Okay, this is a legal document that is made under oath. And what that means is that if there is a lie on it, an intentional lie, someone's committed perjury, which is a crime. Now, this warrant must describe the place to be searched or the persons or things to be seized. It is a written declaration. Now, this can be a little less strict than you might think. When the police are carrying out this search, they have to be reasonable. They're not supposed to use excessive violence or unnecessary violence or destruction of property. And it limits where they can search. If you go get this warrant and you say, we expect Bob Smith to be at 3 Main Street, that's where you get to, execute your arrest warrant. Now, you can have a general one, but if your search warrant says, we need to search 3 Main Street for the presence of a meth lab, you can't go to Maple Street and search with that warrant. You're limited. What can be seized under a warrant? Well, here are 4 things, and some of them are pretty close to each other, but here's 4 things that you can seize in a warrant. Items that are a result of a crime. You rob a bank, you have some of the money. Those could be seized. Items that are inherently illegal to possess. Heroin, cocaine. Items that can be called evidence of a crime. So you might want to say, well, I know someone's got videotape or has got camcorder footage of the robbery. You can seize that. Cell phone. Items used in the commission of the crime. Let's suppose you used a gun to do it and a gun is in your house. We might seize that gun and test it and see if the ballistics match the gun that was used in the robbery. Now, that doesn't mean that you have to have a warrant all the time. Now, you notice that there's nothing in the Constitution that says, oh, by the way, you don't need a warrant in these cases. Okay, so when has the court decided that you don't need warrants? And by court, I mean the Supreme Court of the United States. First of all, incident to a lawful arrest. Let's suppose I see someone commit a crime in my presence. Now that is always granted the authority of the police to make an arrest. You see someone without justification come up behind another person, from behind, hit him over the head with a steel pipe. The victim goes down, he's bleeding. You see this happen, you don't need to say, wow, that was really bad. I got to go down to the magistrate, get a warrant, and go arrest that guy. You can arrest him immediately. Now, when you are arresting him, the courts have said you can seize anything they control. So you can seize that lead pipe, right? You can search his pockets. Does he have drugs on him? Does he have, a list that says, go out in the street and hit Fred on the back of the head with a lead pipe? You can seize the area immediately under their control. But that's pretty much it, subject to an arrest. Here's a recent Supreme Court case. A suspect was coming back, and he pulls up to his house. He's got a driveway that's outside. He's got the police waiting on the front porch. He gets out of his car, locks the car door, walks up to the porch, which is 10 or 20 feet away. Police say, are you John Smith? He says, yes, I am. They say, you're under arrest. And they said, all right, give us the keys. Since we arrested you near your car, we're going to search your car. You just had it under control. And they search the car and they find evidence of crime or criminality. It goes up to the Supreme Court because his lawyer makes a motion that that's not the area under his control. And the Supreme Court agrees. They say, hey, you're right. That's not under your immediate control. Usually we have what's called the arm's reach doctrine. If you arrest somebody, right, you can search those areas that they could reasonably reach from where you arrest them. So in a car, that's going to be the whole passenger compartment. But outside of the car, up on the porch, it's just going to be the area immediately around the porch. And it's certainly going to be their person if you're searching for weapons. Here's the most common type of search: consent. A police officer comes up and says, can we look in your bag? Can we look in your wallet? Can I look in your car? And most people will consent. And the amazing thing as an attorney is I would have clients that would be in jail and they will have consented to search when they had something illegal on them. Sometimes they had a gun, sometimes they had a knife, sometimes they had drugs, which was most common. And I would frequently ask them, and they said, well, why did you consent to the search? And they would always say, I thought if I said no, it'd make them suspicious and they'd search, or I thought they wouldn't search. Now, if someone consents to a search, you don't need a warrant. You don't need probable cause. It's got to be voluntary, okay? If you physically threaten them, if you do it to a minor or someone of low intelligence or someone who could not consent because they're intoxicated or high, different story. But it's got to be voluntary. And I tell my police officers, when I'm at the police academy, this is one of the most valuable tools you can do. You get people to consent. Now, important point, and I can't emphasize this enough if you're a civilian as opposed to the cop doing it. If I refuse to consent to a search, if Officer O'Malley comes up and says, can we search you? And I say, no, you can't. He can tell me, hey, that makes me suspicious. Well, good for you, that makes you suspicious. But my exercise of a constitutional right cannot form the basis or any part of your desire to search and the right or the creation of probable cause, even though in logic it might. Okay. Warrantless searches of cars near international borders are okay. If you're near an international border, you have very few constitutional rights the courts will enforce. So I would say if you're within 20, 25, 50 miles maybe of the U.S.-Mexican border or the U.S.-Canadian border, we can search you. Or actually, Canada's got a maritime border with the Russians, so U.S.-Russian border. Absent suspicious circumstances, the police are going to need a warrant to draw blood if they're charging or investigating a DUI. Searches can be done over the objections of the property's owner if the lawful resident consents to a search. It's not just always the owner of the property consent. These are just a few recent cases. And again, if you take our constitutional law class, there are dozens of these cases we'll look at. Okay, we're going to talk about automobiles, and I said before we are an automobile-centric, which means automobiles are the core of our society. So there's a lot of case law in the 20th century on automobile searches, and we do not have time in the next 5 minutes to cover each one of these. So here's just a quick and dirty look at it. The expectation of privacy in cars is lower than in your home. I mean, you've got windows, right? And you're out in public. Warrantless searches of cars are okay if I'm arresting you for another crime. So I stop you for speeding, if I stop you for rolling through a stop sign, I can conduct a search. I don't need a warrant if it's non-intrusive searching. Looking in the car is non-intrusive, and this is the famous drug dog search. So if I say, you're going to wait here for half an hour, I'm going to get a drug dog, and it's going to walk around the car, that's not a search that I would need a warrant for. You can search containers in cars if you have a reliable tip. Now, I am not going to go that far in that because there's some different case law between passenger compartment and trunk and sealed objects and not. But basically, just understand that in the passenger compartment, it's pretty much open. Why the police stop your car is irrelevant, but they must have some violation of law to permit a warrantless search. Okay, here are two of these exceptions that most people don't think of: plain view and open fields. Again, John Doe's walking down the street, he's got a joint in his hand, he's taking a hit. If the police can see this illegal item, I don't need a warrant to seize you, I don't need a warrant to seize the drugs. Now, obviously, for plain view to apply, it's got to be something that's obviously illegal. If I see you reading a piece of paper, I can't say, oh, I bet that's a plot to blow up the Brooklyn Bridge. You got to immediately be able to recognize it illegal. And most of the time, this is going to be a drug or weapon. Now, here's a big surprise for people because it's how your home rights are a little bit limited. And I'm going to introduce a couple quick terms here. Not in the text, not in the notes necessarily. The terms are, the big term I want to introduce is curtilage. Curtilage is the area immediately surrounding your house which enjoys extended protection. Inside your house, you're going to need a warrant. But you kind of move from outside your house gradually. Now, I'll say this. If some area is fenced in so that you have to physically open gates or jump over fences, you probably got an expectation of privacy. But beyond that, think about the standard house. We'll just look at a standard suburban house. Okay, you've got the home, and you may have a few buildings that are associated with it. Like you might have a garage that's detached. That would still be part of the curtilage. You're still going to need a warrant if you go in there. But most single-family homes, right, they're going to have a lawn. So can the police officer walk on the lawn and see if he sees marijuana plants or if he sees a gun that might have been thrown away? The answer there is yes, and he doesn't need a warrant. Now, I can order you off my property. I can say, hey, get off my property at this point. And police have to obey private property laws as much as anybody else. This is also open fields tangentially related as to why, sorry that came up, as to why they can fly over your property in planes and conduct searches. Okay, let's talk about electronic surveillance. First of all, in electronic surveillance, we really like to have a record, a recording of either a video recording or an audio recording of what people said or did. And when can the police make these recordings? Well, it kind of depends. There are two broad types of states when it comes to this. What are called one-party consent states and two-party consent states. North Carolina is usually a one-party consent state. That means if you've got two people talking, if one party consents to it being recorded for the police don't need a warrant. But if you're eavesdropping on both parties, you're generally going to need a warrant. The police will go and they'll say, we want to tap the phones or tap the computer of John Smith because we think he is plotting to plant a bomb in the General Assembly. So they're going to describe what they're going to overhear, who they're taping, and why they have probable cause to believe this. And then they're going to be allowed to place a tap and record. Written communications that are electronically generated have less protection. You'd be shocked how easy it is in many ways to get financial records from banks or email conversations because they just enjoy less protection. All right, what about cell phones? Well, the police have done things like stingray operations where they simulate cell towers to track phone locations. This seems to be reasonable according to it. Now, here's an interesting one. And this kind of came back, and I would say, and bit the Supreme Court. And let me give you a quick analysis of this. Recently, the Supreme Court seems to be getting ready to vote to overturn Roe v. Wade. Probably by the time you're reading this, the case will have come down, because I'm recording this in June of 2022. And we're expecting that decision to come down that's written by Alito. The actual draft of the opinion, the one that's not been published yet, was leaked. Now that's a big no-no. And the Supreme Court would like to know who leaked it. So they go around to all the clerks of the court, which the clerks of the court's a very prestigious position. It's usually a third-year law student that's hired, and they work for the court for a year. They actually help write constitutional law. It's an amazing job if you can get it. So obviously they think that one of those clerks might have leaked it. That'd be a possibility. And those clerks probably talked to someone in the newspaper. That means they use their phone or their computer. So what did the Supreme Court want? They want their phones. They say, okay, let us search your phones. Well, they had a case, California versus Riley, which says if you're going to search someone's phone and they object, you got to go get a warrant. And you can't simply search everybody's phone without believing probable cause that this person might have been involved. So you can see how Supreme Court cases not only can impact the greater society, they can impact the court itself. All right, here's one of the heart cases. And if you're following in time, usually I try to keep these about 50 minutes. But we're going to go a little bit over just so you're aware. Terryv Ohio, and I'll simplify this case. This is arguably one of the most important cases in the 20th century when it comes to criminal procedure. And you should read the case. The factual situation I'm going to give you is a little bit different. I'm just giving it to you so you can fix it in your mind and understand it. So we have Officer O'Malley walking the beat, and he sees three individuals that look very suspicious. They got trench coats and hats pulled down over their face, and they're out in front of, I'll make it simple again, a liquor store that it's 9:55, it closes at 10, and it only deals in cash. And Officer O'Malley looks and says, I bet those three are up to no good. Now, I don't have probable cause to arrest them, but I need to stop them. Oh, but here's the problem. Remember, it's 1968. Cops don't have radios. I can't call for help. I'm going to have to approach three men at night who may be getting to rob a store, which means they might be armed. I have got to be able to stop them, isolate them, and pat them down for weapons for my own safety. So that's what Officer O'Malley does, and lo and behold, he finds a gun. And the three individuals are arrested. Forget about robbing the liquor store. One or more of them were the next convict, not allowed to possess weapons, so they're going back to jail. They're also getting jailed for possession of that firearm. Goes up to the Supreme Court of the United States because those suspects say, hey, look, the Fourth Amendment says, you've got to have probable cause for a search. And the Supreme Court of the United States says, no. If I can reasonably articulate, given a totality of the circumstances, that a crime might be getting ready to occur, I can stop an individual, and then, not for the reason I stopped them, but for my own safety as a police officer, I can conduct a non-intrusive search, which really means a frisk or a pat down. So I can run my hands over the guy to see, do they have a gun? That's what I'm allowed to do. That's what Terryv Ohio says. Courts say, let's look at the total circumstances and see. Now here's the interesting thing as it's applied. If there are 100 stops where the police can articulate why they're suspicious, they're wrong 94% of the time. Now that's a pretty poor success rate. That would argue that in the factual world, Terry stops, either they're being done inappropriately, without really being able to articulate, or something's gone wrong here. Even if we look at most of the arrests are not for weapons. Remember, Terry is based on a weapons search. Most of the arrests are for possession of drugs. Because a lot of what happens here is they stop a suspect, they make them turn their pockets out, and what falls out is marijuana or cocaine or meth or heroin or whatever it is, or fentanyl, and they're arrested for the drugs. Also, the most common weapon they find, interestingly enough, is knives, not guns. So stop and frisk, a stop is the very brief detention. We can't hold you for a day or 2 days. I still need reasonable suspicion. The frisk is a pat-down, and this is done for the protection of the officer and can lead to, quote, inadvertent discovery of criminal evidence, typically drugs. But who gets stopped? Okay, so let's look at the demographics of New York City. This is a fairly famous pie chart. So let's look at if you're white in New York City. You're about a third of the population, and you're 10% of the people stopped. So your odds of being stopped should be, 1/3 of all stops should be white, but only 10% have stopped. So your odds are 1/3 of what they should be. Now, if you're black, about 25% of the city, you're stopped half the time. So your odds are doubled. So what are the odds if you're black versus white? Well, you are 6 times more likely to be stopped if you're black than if you're white, because you have to multiply those two. Hispanics actually are stopped at about this right level, 29 to 31. Others, that's very problematical. They're stopped at about half the level. Those would be, I assume, primarily Asians. I would love to see one, by the way, if you looked at gender, because I think what you'd find is that roughly half the city is male, half the city is female. But I think you'd probably see that most of the stops, I'd probably say 80%, 90%, are male. So, that's one of these things about profiling. Are you gender profiling? Is that acceptable? And then, what about if you controlled it for economic group? Are you making these stops in the best parts of Manhattan? I'll just about guarantee you're not. So, do a chart there, break it down in fourths, richest fourth, poorest fourth, the two in the middle. I think you'd see a big change there. Okay, race and reasonable suspicion. According to the law, a person's race, gender, or ethnicity alone is not reasonable suspicion for stop and frisk, but they're allowed to play some role. Racial profiling, the practice of targeting people for police action based solely on their release. Now, solely is the key there. Their ethnicity or their national origin. Now, this is wrong. Okay, this can be remedied by either civil lawsuits against the police or the agencies, and you're trying to not only that person's constitutional rights are being protected, but that group of people. And one of the questions has become, well, what about immigration? So, for example, not too long ago, Arizona empowered people to check immigration status of any suspect detained for any other reasons. This could be a stop and frisk, not someone you're arrested, but let's suppose I stop you because you look Hispanic, and I say, let's see your immigration status. Prove to me you're American. Is that okay? Could you do that at the Canadian border for a bunch of white Canadians, eh? Could you say, oh, hey, you're a hoser, man. You're obviously from Canada. So I'm going to stop you because you're white. All right, we've talked a lot about the search. Let's talk about the seizure. A little bit simpler concept to wrap your mind around. An arrest can arise because I have a warrant, that's the best one, or because I saw the crime, or because of evidence discovered in a stop and frisk, or a search. The elements of an arrest is you must intend to arrest somebody, you have to have the authority to arrest them, they actually must be seized or detained, and they got to be aware, basically they got to be awake or aware. Arrest with warrant is best because you've already established your probable cause. You've gone to a neutral judicial magistrate, a judge, and you said, here is the suspect's name, here's the crime, here's the location, I've got probable cause. The judge looks and he goes, yeah, you do, go arrest him. Now, typically these are, you serve these with a knock, but you can have no knock, and these are somewhat contentious in our society, and they seem to have been increasing. If we think the suspect is armed or there's a felony in progress, or evidence might get destroyed, we allow no knock. They can lead to the preservation of this evidence, or they can lead to greater police safety, or sometimes they can stop a felony, but also they can lead to tragedy. That is a North Carolina arrest warrant. You'll notice that it's a little bit different than your search warrant. It says warrant for arrest. It's got much of the same. This is filled out for Rowan County. And this is one for an individual, Joseph Myers. And you'll notice they've got the charge there. Failed to return property, one VCR movie entitled Freddie Got Fingered to the possession of J&J Video from who you rented it at the expiration of the time. Believe it or not, this is a warrant to go arrest somebody, misdemeanor probably, essentially for not returning a videotape. All right, what about arrests without warrants? Can we do those? Yes, we can. Again, you commit the crime in the presence, you believe you committed the crime, there is the danger of the guy getting away, and location is usually the key here. I will say this in North Carolina, if you look at the North Carolina Supreme Court, if you're a North Carolina police officer and you arrest someone without a warrant in their home, the courts are going to look very suspiciously at that, and they're probably going to toss the arrest, and anything you find subject to the arrest, that's the exclusionary rule. Man's home is his castle in North Carolina. All right, now we're going to move on, Fourth Amendment to the Fifth Amendment, and I'm just going to highlight part of the Fifth Amendment. It says, no person shall be compelled in any criminal case to be a witness against himself. Now, you can be required to give, at least in some states, identification. What's your name? Where do you live? It doesn't protect you if you're in custody from non-testimonial evidence. So if I arrest you and I say, did you kill Bob? And you say, I'm exercising my Fifth Amendment rights. They can still say, okay, we're going to take your fingerprints. You can't do that because those fingerprints are going to be used against me. Courts have said that's non-testimonial evidence. Fifth Amendment only protects you from testimony. So we can take physical evidence, we can take fingerprints, even DNA. All right, so interrogation by the process and Miranda. The police may ask any question before arrest. One of the most important tools the police have is they can come up to someone and they can ask questions to them. Again, police officers are trained to not make the arrest, but to help build their case. You don't need a warrant or even probable cause to ask a question. And then they can use anything they discover to make that arrest. However, and I can't emphasize this enough, exercising a constitutional right, not a basis for an arrest or for suspicion. Once you're under arrest, you have the right to remain silent. This applies only in criminal cases, not civil, because there's no arrest in a civil case. It applies only to communication or testimony, not to physical evidence. And there's a couple critical cases here. Again, if you take that constitutional law class, we'll talk about Miranda versus Arizona and the Escobedo versus Illinois case. But here's the Miranda case. Came down in 1966, and the court said if you're under arrest and in custody, you can refuse to give information. Here are your quick rights. You have the right to be informed, you may remain silent. You have the right to an attorney, and you have the right to know what you say can be used against you. Now, there's a couple subsidiary rights that come off of those, like if you can't afford an attorney, we'll appoint one, and do you understand all these? But those are your three basic Miranda rights. When does it apply? It applies when you're arrested or you're not free to leave. So after a stop, but before an arrest, you can be questioned. It is not if you volunteer information. So often a good police contact to just get a suspect talking is good enough. Not when the police are not interrogating. So if the police are just talking among themselves and you volunteer something, Miranda isn't covered. Or if you're in a jail cell next to someone else and you talk to him, even if the police have put him in there with the intention of getting him to talk to you, after you've said you Miranda doesn't apply. Recently, the Supreme Court has been admitting evidence even without Miranda warnings. And many defense attorneys feel that death by 1,000 cuts, or the gradual buildup of so many exceptions to Miranda, is effectively killing it. In fact, there are some Supreme Court cases this summer that might spell the broad end to Miranda. All right, we're going to kind of conclude with false confessions and convictions. Recent empirical studies show that suspects waive Miranda about 80% of the time. Believe it or not, about 8 out of 10 people talk. And suspects will show a very strong desire to cooperate with the police and to please them because they're in a stressful situation. And sometimes they will even confess to crimes they didn't do. These are false confessions. Why? 1, it can be voluntary. First of all, you can have delusional people. People are mentally ill. People are confused. People are seeking attention. They may confess. Then there are vulnerable people, people that are suffering from stress of the interrogation. And then there are those that are compliant. They know they're innocent, but feel that it's in their best interest to confess, like they're told. So there is also, and we're going to look at some numbers, extreme cases where people are physically coerced. These are your cases of wrongful conviction. Now you notice what winds up getting you, and these are about 85 cases of wrongful conviction. This is published more than 10 years ago, but first of all, bad lawyers. That can lead to a bad conviction. Questionable forensics, that can lead to a conviction. Witness testimony incentivized, these are jailhouse informants, but right there, 33. So roughly 40% of wrongful convictions are based on false confessions. Then you've got bad eyewitnesses or police misconduct. And you'll notice they don't all add up to 85 because that's the number here, because you can have multiple reasons. So the identification process, how do we find people? We're going to get back to false confessions right at the end, but hold on a second. Simple non-testimonial questions are not viewed as incriminatory. So unless the witness by the police, there are 3 options to identify them. So you can have a show up, you can have a photo array, or a lineup. And each of these is viewed with some suspicion by the courts. So if we say we've got this witness, he's got to identify, did we get the right guy? We've got show-ups where you catch the suspect close to the crime and you bring in the witness to say, is this the guy? You're only showing him one person. Courts are very suspicious of those. Then you got photo arrays. Those are okay, but again, they can't be unduly suggestive. I can't take a guy, let's suppose my guy looks like Kobe Bryant. And who would I put in the lineup? I put Kobe Bryant in the lineup, and I put, I'm trying to think of 3 people don't look like Kobe Bryant off the top of my head. I put Angelina Jolie, who's a white woman. I put Maggie Q, who is an Asian woman, and I put RuPaul, who could never be confused with Kobe Bryant. Of course, don't worry about Kobe being alive or dead, but that would be unduly suggestive. And then there's lineups, and again, you're supposed to have people that look somewhat similar. Same gender, same race, same approximate height and dress. You can't have 3 cops in uniforms standing next to one suspect who's handcuffed. That'd be a bad lineup. All right. The police have physically tortured people into confessions as well. They have coerced them. You've got John Burge, a police commander in Chicago, who ran a unit that for 20 years, between 1972 and 1991, physically tortured suspects. They had actually a hidden precinct, what they call a black site, where they would take suspects to coerce them into confession, videotape the confession, or record the confession, and then use it in court. Physically coerced confessions are inadmissible, and they are unreliable. And the example I'm going to use here is the Central Park 5. There were a series of fairly brutal attacks in Central Park way back. This was in the 80s and 90s. And the police were under a tremendous amount of pressure to catch the people. And 5 black youths were caught. And then they ranged in age from 14 to 16. They were really coerced into confessing. A lot of pressure was put on them. Later, in 2001, the real rapist was found. In fact, because the statute of limitations had run, he came forward and DNA confirmed that, yeah, this is the guy that did the rapes. But you had 5 people in jail. And you had Donald Trump here. I'm not trying to be critical of Donald Trump, but you had this full-page ad that was taken out in the newspaper that said, "Bring back the death penalty, bring back our police." It's the idea of, we can always trust the police to do right, and that's why we have a constitutional law. This is the timeline. There's a movie, I think it's on Netflix. I'd recommend if you take a look at it, where it goes through this whole process, and it kind of gives you an idea what went on. So in 1989, you have the female jogger who's assaulted. She's discovered by the police. They arrest these 5 boys, youths, and they're charged with rape and murder and assault. She regains consciousness. Interestingly enough, the real attacker was committed another rape, and then he was released. Then we have all 5 of them are convicted, and then there's some evidence that someone confessed, but they didn't confess, and when the judge looked at it, they overturned it. In any event, it's an interesting documentary. I recommend you see it, because it'll give you an idea about how, it's not we took them in the back and we tuned them up with batons and we got them to confess, but how you can generate a false confession. So When They See Us is on Netflix. I'd recommend taking a look at it. It won't hurt you. Okay. About 10 minutes over what I like. It's about an hour and 10, but we finished this chapter, and I will see you for the next whenever you're ready. Have a good morning, afternoon, evening, day, weekend.